Let me make sure I have all counsel here. Earlier, we received notice that Mr. Mayor is going to do argument. Mr. Newmayer, will you be doing it all?
No, Your Honor. May it please the court. Mr. Mayor and I are on the
There
same
he
side.
is.
Yeah,
There he is.
we're on the same side of the case.
Mhm.
What we'd like to do is to jointly reserve 5 minutes for rebuttal. I'll take the first 7.5 minutes, and Mr. Meyer will then conclude our initial presentation. He will in part be focusing on, per his answer brief that was accepted as an initial brief, the technical points of statutory interpretation and the other points raised. So that is how we intend to move forward here.
Will you also be dividing the rebuttal argument in a similar manner, half and half?
We have to kind of play that one by ear, Your Honor.
So I should listen for the notes.
Well,
That's
Yeah,
fine.
Yeah, I think Mr. Newmeyer and I had talked about he would take the lead on rebuttal and do and he can either do the whole thing, or he and I will make a clear indication to the court.
No problem. I just don't want to shortchange anybody because
Yeah.
I'm not sure the process you'd like to follow. Since this will be left to you, then we will say, what is it in the Uniform Commercial Code? The risk of loss is with you. Is that right? In case I miss any seconds here. Okay. With that, I think the panel is prepared to entertain argument at this time. And Mr. Newmeyer, if I understand the presentation, you would be our initial presenter.
yes, thank you. May it please the court, Mark Newmeyer for the appellant. So this case presents for appellate purposes in a very crisp manner. There was a dismissal of a petition for determination of parental rights, time sharing, and so forth. It was entered based on a finding by the trial court that there was a statute that barred our client's participation, my client's participation, and dismissed his petition accordingly. The court took evidence relating to best interests of the minor child and so forth, but did not reach the point of making any findings, rendering any findings of credibility on those issues.
Mr.
Instead,
Newmeyer, I
it
have a
ruled.
question.
Yes, sir.
I have a question. Was there a definition of commissioning parent? Because this case comes down to the definition of commissioning parent. Is it by statute that the court decided, or was there some sort of case law definition or statutory definition?
There is actually a statutory definition. It's in 742.13, the definitional statute of the, or provision of the assisted reproductive technology. That's subsection 2. And it reads, commissioning couple means the intended mother and father of a child who will be conceived by means of assisted reproductive technology using the eggs or sperm of at least one of the intended parents.
There's a
However,
definition of commissioning parent. That says couple. What's the definition of parent?
it does not define parents, Your Honor, and unfortunately in today's technological world, there may be more than one parent,
No,
depending on the
I get all
context.
that. No, I understand all that. So my question comes down to, didn't the trial court reject your client's interpretation of commissioning parent and found he had no credibility in that realm?
The court did make that finding. However, it should not have reached that finding. Our position
You say the
is that,
facts otherwise.
yeah, the facts are not otherwise. Our position is this is a de novo interpretation or review of whether that statute applied at all.
Okay,
And
so the credibility determination is immaterial in your view.
it is. If we're using the wrong statute, then we don't need to worry about commissioning couple,
Okay, I got you.
anything else. So because it presents so clearly, it provides this court with the task of determining whether, from our position, its own decision, this court's decision in AAB from back in 2013, will retain ongoing validity. There were similar issues in that case. there was a do-it-yourself insemination of a lady by a gentleman. The court ruled that although there was no laboratory handling of eggs as required under the definition of assisted reproductive technology, nevertheless, the operative provisions and restrictions of the statute dealing with assisted reproductive technology would apply. That is, unless there was an appropriate signed document by the male, or there was an agreement by the commissioning couple, those two exceptions within the statute.
And we have neither here, do we?
We have neither here. Therefore, the rather draconian results set forth in the statute, which is basically an irrebuttable ruling that the male's parental rights are terminated and of no further validity, would ensue. So this
So is AGR a donor?
AGR was, well, it depends. Unfortunately, donor is not defined under the statute. If we are dealing under the statute, it may be that he was a donor. The problem is, again, we are shoehorning a case that it did not involve laboratory handling of eggs, therefore is not assisted reproductive technology related.
Well, but let's focus on that. So not laboratory handling of eggs and not, assisted reproductive.
Yes.
How do you define that? I mean, what happened in this case is certainly arguably within the realm of that kind of a definition.
Your Honor, I would respectfully submit that it is not. There is a separate statute dealing with artificial insemination. Wouldn't that be closer to what happened here? It was do it yourself. And as the court in Enrique, who is clearly directly in conflict with this court's ruling in AAB, pointed out, if we're saying there needs to be no laboratory involvement,
Well,
then,
okay. Well, let me stop you there. What is laboratory involvement? I mean, you mean something on a kitchen table can't be a can't that be a laboratory?
theoretically,
You have to hire
it
a
could,
big corporation and pay them a lot of money to qualify for the statute?
I guess, but the legislature did in fact define technology as involving laboratory handling of human eggs or embryos. There clearly was no laboratory involved here.
Well, I'm not so sure about that. I mean, certainly it's not a sophisticated laboratory. Certainly it's an unsophisticated situation that occurred, but I'm not sure that is it. I mean, there are all kinds of laboratories. There are really complicated, sophisticated ones, and there are some pretty crude, rudimentary ones.
Yeah, the problem is, Your Honor, if we chase down what we would pursue or characterize as that rabbit hole, if you can say a bowl sitting in warm water and a syringe is a laboratory, then what if you don't use the syringe? What if you use your finger to insert it? What if there's no bowl? What if you take it off of one person and put it into another? At what point does the technology get defined? It's not defined in the statute. The only definition
I'm with you on that. So at
Yeah.
what point is the sophistication level sufficient to call it a laboratory? How are we going to draw that line? I'm with you on the complications of drawing the line you described. Now, to help me draw the line that I've just described. How complicated does it have to be? You have to pay a lot of money?
And you want to do it quickly because we're just after 7 minutes. I don't want you to expire of time.
Yes, it's kind of, if you look at the full definition, it's laboratory handling of human eggs or pre-embryos. That's a clause. So there was no handling of eggs. There was no handling of pre-embryos. So whatever kind of laboratory we're talking about has to be one that handles either eggs or pre-embryos, including but not limited to, and it has a whole list there. This is not a case where it says laboratory handling of sperm. That is not what the legislature said or obviously intended. Or insemination, artificial insemination would have been covered in this provision. It's laboratory handling
we're
of
past
eggs.
7.5 now.
Okay.
That's a
so-
fair
let me-
point.
Let me, pardon me,
Yeah,
Judge Morris, I didn't hear your.
I just said he made a fair point.
so I'll go ahead and hand off to Mr. Meyer again, who's well up on and more up on the legislative interpretation than I am.
Perfect. Thank you so much.
Thank you, Your Honors. May it please the court. My name is Eric Mayer. I represent ANIB, who is the biological mother and the birth mother and also the intended mother. And I wanted to pick up where we're leaving off because I think the issue of the location of the procedure is sort of a red herring. The point is, assisted reproductive technology requires that human eggs are handled in a laboratory outside of the body of a woman. So typically it's either going to be eggs are removed from one woman, fertilized outside in a laboratory, and then implanted into another woman who is either going to be a surrogate for this couple, one of whom donated an egg, one of whom contributed an egg, or she may be the recipient of a donation. So the purpose of this statute is 742.14 is to identify who is the mother, because the fact that we have this technology now creates the possibility that two people can actually be what we would always think of is the mother, one person giving birth and the other person actually the biological mother who contributed the egg. So the definition is clear that it has to be an egg that is removed from a woman's body and handled in a laboratory. So that's not going to happen at a kitchen table, but frankly, it doesn't really, it's not, the court below was focused on the location and whether or not doing it in a living room versus a laboratory, is dispositive, but really, in neither case, even if you went to a laboratory to do what these people did, it would not be assisted reproductive technology because it did not involve the removal of eggs from a woman's body and the fertilization process outside of the body and then implanting it into another person. And if
So is AGR a donor?
not under 742.14, not a donor. He contributed the sperm, but he's not a donor because 742.14 the word donor, and it's not defined, and this makes this case difficult. It means a donor who contributed biological material for the purposes of assisted reproductive technology, and this was not that. And if the 742.14 were applied to the procedure that were used here, it would never be possible for somebody in AGR's position to maintain parental rights because it's impossible by definition for him to be part of a commissioning couple, and it's impossible by definition for him to be a father who is a party to a pre-planned adoption agreement.
So
Assuming
there's no,
742.14 applies, what is the purpose of 742.14? Is it to cut off rights of
Yes,
sperm donors, for example?
So if you look at 742.15, it requires that all gestational surrogacies are documented and they have a written agreement between a gestational
And that doesn't
surrogate
apply here. There's two
and
exceptions.
and a commissioning couple. That's what a commissioning couple is. It's a party to one of these agreements. So without a gestational surrogacy, there cannot be a commissioning couple because 742.15 is really what sets forth, well, what is the purpose of a commissioning couple? It's to commission with a gestational surrogate who agrees to have a child for somebody else. And 742.11 defines commissioning couple in terms of this assisted reproductive technology, which in turn requires the handling of eggs outside of the body. So the purpose of the statute is to say, okay, everybody here, there's two possibilities because we don't want to consider subjective intent anymore. We're either going to have an agreement where there's a commissioning couple who makes an agreement with a gestational surrogate and the commissioning couple is going to retain their rights, or if there's no agreement, then the person who has the child is going to be the mother, and the contributors of the DNA are going to be considered donors who lose their rights, because as the court in DMT made clear, we don't want to get into subjective intent, because one subjective intent and the two people may have a misunderstanding, but we want to make it very clear, if a woman gives birth to a baby using eggs that were contributed by somebody else, we don't want to then have to get into a swearing match about what did you think was supposed to happen and what did you think was supposed to happen. Rather, there's a commissioning couple. There's either a commissioning couple that's a party to a gestational surrogacy agreement under 742.15, or there's not. And if there's not, then anybody who contributed DNA is going to be considered a donor to the woman who had the child, and the woman who had the child is going to be deemed to be the legal mother. And so that's really the purpose of the statute. That statute was necessitated by the fact that we can now have one woman give birth to a child who has with the eggs of another child. And again, in that case, we want to say, well, who's the mother? And we need a really discrete set of rules to identify who's the mother, so we don't have a situation where somebody says, well, I thought they were being donated to me, and the other woman says, no, I thought you were having the child on our behalf. So without a written agreement, the woman who gives birth to the child is going to keep the child. If there is a written agreement, that agreement per 742.15 is between the commissioning couple, and that's where that phrase comes in, and the gestational surrogate. But there cannot be a commissioning couple without this type of without this type of dichotomy between the gestational mother and the DNA mother. There cannot be a commissioning couple in the situation where somebody injects sperm directly into a cervix of a woman, like was done here. Nor would it be possible in a situation such as this for there to be a pre-planned adoption agreement, because a pre-planned adoption agreement requires that the person who gives birth is going to be what's called a volunteer mother who denounces and gives up her rights upon the birth of the child. So what happened here is my client had a child with AGR, but chose not to have sexual intercourse with him. And the court would
So counsel,
in order to have
counsel, let me ask you a question here.
Sure.
Hold
Are you
on.
able,
Let's see,
Yeah.
Craig, were you asking one first? And then Judge Morris, I know we're on video here and it kind of breaks up, but I thought I heard Judge Volante's voice first.
No, it wasn't my voice. It was.
Okay, then it was Judge Morris. Pardon me. Go ahead.
okay, that's no problem. Counsel, can you harmonize the 5th District's opinion in Enriquez and our opinion in AAB?
I
Are
really,
they at odds or can they be harmonized?
frankly, they are at odds, and I think there's two questions to be asked. One is whether this procedure that was used in this situation, and it was the same as in Enriquez, is assisted reproductive technology. And both the dissent and the majority in Enriquez said, no, it's not. They recognize it's not. And then they went on to the second question of, well, the 742.14 only apply in the case of assisted reproductive technology. So in AAB, this court really assumed, and I don't think it didn't really addressed it squarely whether the procedure at issue was assisted reproductive technology. What happened in AAB was the court below said the statute doesn't apply because these people did this procedure in their living room, not a laboratory. And then the question for this court was, well, does that matter? And the court said, no, it doesn't matter. And I suppose in there is a presumption that it is assisted reproductive technology, but it really didn't specifically address that. So both the dissent and the majority in Enriquez recognized that this was not assisted reproductive technology, and the split they had was on the question of whether, well, does the statute apply only when there is assisted reproductive technology, or could it also apply, whereas here eggs are not handled outside of the body and fertilized outside of the body. And that was the split in Enriquez, is the majority saying, no, it only applies, 742.14 only applies when you have assisted reproductive technology, and the dissent saying, no, it applies even if you have a procedure that is not assisted reproductive technology, but also not what is court in AAB called the old fashioned.
So the dissent and AAB are pretty in sync. The Enriquez dissent.
No, I don't agree with that, because
I don't need to do it, but the way the time was divided, we passed 7.5 minutes, almost 4 minutes ago. And so I need to say that we have finished, and go ahead, ask your questions, Morrison. I'll just make sure the appellee gets enough time to even it up.
I heard
Or answer the question about the comparison between the dissent and Judge Kelly's opinion, I believe.
May I answer that one?
Yes, please, and then we'll
Okay.
end there.
The question was whether the dissent in Enriquez is in sync with AAB, and the answer is, I think the answer is no, because this court in AAB either held or assumed that the procedure that was used, same one used here, same one used in Enriquez, was assisted reproductive technology. Both the dissent and the majority in Enriquez recognized that it did not constitute assisted reproductive technology, but the split between the dissent and the majority was whether, okay, given that it did not involve assisted reproductive technology, does 742.14 apply anyway, or is it limited strictly to situations where assisted reproductive technology is used? So I don't think that's not AAB is not consistent with the dissent in Enriquez.
Thank you.
Oh, that was the end of my time, I think, correct?
Yeah, he's moving on.
Actually, that'll be 20 minutes already. But we're going to try to preserve your rebuttal time, and I'll do that by helping the appellee out with some time here after I do my math. Since they've had, I think, 20 minutes, counsel, and they're reserving 5, you would have 25 if my math was right. Now, you should take that with a grain of salt, because I was a liberal arts major.
Sounds good, Your Honor.
Okay, thank you. You may proceed when you're ready.
Thank you, Your Honor. May it please the court, counsel, I am attorney Robert Ongstad, and I represent the appellee JS. I'd like to first begin by addressing the court's questions to the appellant. I do believe and would argue that the dissent in Enriquez very much aligns with this court's opinion in AAB versus BOC, which I understand, Judge Casanueva, you were one of the ruling judges on that opinion. The dissent makes it very clear.
And I point out that the author of the dissent now sits on a higher court, right?
That's right, Judge Sasso. That's right. So in the dissent, he really explores how the majority opinion in Enriquez, because that's the first opinion to go against this, seems to increase limitations on the statute that didn't exist. I would point out that the statute definition of assisted reproductive technology does not include sperm. And so 742.14, which is the only statute that directly affects the donor's rights, does specifically include sperm in that. And it's important to note that in DMT versus TMH, the Florida Supreme Court did give the reason for this statute, which was to protect couples from interference of third-party donors. which is exactly what we have here. We have a case just like where we have a third-party donor. I point to the court to the record where, you know, this is the third person that the couple asked. This is the second person that they tried with. And this procedure, again, this isn't the biological mother and the, I'll refer to him as the donor, but the giver of the specimen came together and had a child. And it's important to note too, where the procedure occurred and the interaction of the parties. So we have a situation where JS greets the donor at the door. He goes and provides his cup into a specimen and then delivers that to JS, whereas the biological mother is in a completely different room. So there is no doubt, based on the facts of this case, that the donor knew or should have known that he would, you know, that the women in this case were an actually existing couple. We also have
but given the relationships of AGR to certainly to AIB or AN, I get these initials mixed up, ANIB, is there no scenario under which he could be considered part of a commissioning couple?
No, there's not, Your Honor. And the court made, this court made that clear in Lamari-Tata v. Lucas, which was quoted directly in AAB versus BOC, wherein the court held that in order to be a member of a commissioning couple, you have to fit some sort of rubric of a couple. So with the facts that we have in this case, there's clearly a couple because when the child is born, we have a legally married couple. So because the AGR was not in any sort of rubric of a couple, he cannot be considered a member of a commissioning couple.
May I ask a question about the textual interpretation of 742.14? I know if I ask it now, there's a chance I'll get another response and rebuttal. And my first view is, does it provide a general rule followed by an exception from the general rule for which a person would have to assert that they fell within an exception? Let me do it this way by saying what the statute would read in this case. The donor of sperm shall relinquish all paternal rights and obligations with respect to the donation or the resulting children, period. That will be the general rule unless the donor can prove they are a part of a commissioning couple or a father who has executed a pre-planned adoption agreement. Would that be a correct reading of the statute and the policy dictated to us by the legislature?
I believe it would, Your Honor. That there's the general rule, which is that
You've got commas setting off in the phrase other than.
Right. So the challenge, because the way the statute reads is, in essence, because again, we're talking about protecting parents from interference of a third party. So we have a situation where it says you're out unless you do A or B. So a member of a commissioning couple, and one could argue that in the Enriquez case, he could have been a member of a commissioning couple because, I mean, the facts are different. Whereas here we have an intact couple receiving a donation from a third party. In Enriquez, it was a man and a woman that decided they were going to create a child together. But again, I agree with the dissent because it appears that the dissent, which does adopt the position, and actually references the AAB versus BOC. What was really interesting, because I know we're talking statutory interpretation, if the court looks at the footnote in the dissent, it talks about the Uniform Parentage Act, which is a predecessor to the current statute, how it was amended. So originally in the Uniform Parentage Act, the term "to a licensed physician" was in there, and then it was removed. And the footnote says that, well, that's to protect people from having, that can't afford to have laboratory procedures or to have, let's say, a doctor perform the procedure, since, as we discussed earlier, the laboratory is not so clear because there are many formations of laboratory, but to ensure that those people could enjoy the rights of being parents and again, be protected from third parties. So for me, the status is very clear because the AGR is a donor, and just like in AAB versus BOC, the court had very, very similar facts and very clearly found that the gentleman was a donor in that case. So we have this court finding it. And again, so we have this court clarifying, we have DMT with the Supreme Court clarifying the statute. I also want to point to the dissent in Enriquez, where he specifically references DMT, because in the opinion in Enriquez, the majority opinion references that in DMT, they keep referring to it, 741.4, as the Assisted Reproductive Technology Statute. But as the dissent correctly states, assisted reproductive technology is not in 742.14, and that was not the actual, so there's no contents there. And if the court applies the plain meaning rule, which I'm asking the court to do, there's no requirement that this court find that the at-home insemination utilized assisted reproductive technology for 742 to apply, because again, it's not about determining who the commissioning couple is. It's not about determining what ANIB versus JS's rights are. The whole issue is about whether a GR has standing to establish paternity, which the court correctly found below at the trial level. The court does not. I do agree to answer the judge's prior question about whether this court directly conflicts with or whether it can harmonize with the 5th District in Enriquez. And it may. I point out that the Enriquez majority opinion does not reference AAB versus BOC at all, and they seem to rely on the assisted reproductive technology definitions more than, whereas this court in AAB versus BOC does not mention assisted reproductive technology. They mention at-home insemination, do it yourself. So they could harmonize, but I actually would agree with the appellants that they do appear to directly conflict. And one of the reliefs we're requesting, if the court does affirm, is to potentially certify conflict based on the court's finding. I would especially point to the dissent, though, and adopt the arguments made in the dissent about applying the plain meaning rule. And then specifically at page 158, where the dissent disagrees with how the majority opinion got to their finding, and talks about the limiting nature of the definition of commissioning couple, but also how, more importantly, the legislator has not limited the definition of donor. And then it also goes to the plain meaning rule over legislative intent and accurately states that the statute is what it says it is. Because if we look at legislative intent, we're not talking about a single unified intent. We're talking about hundreds of legislators over the period of years. Because again, the statute 742.14 is a 1993 statute that's had no revision since. And again, so when this court correctly held in AAB versus BOC that the do-it-yourself manner does not matter, it also, called that he's a donor, because that's what it's about. Is AGR a donor? And if he's a donor, he has no rights. He's a statutory stranger to the parent, as this court said in Lamarita v. Lucas, referring to Mr. Lucas. So I do ask the court to affirm, and I'm happy to answer any other questions that the court may have.
I don't see any questions at this point, so thank you very much for your presentation. And let me clear the clock here. Stop. Cleared. Mr. Newmeyer, you have a mute on, but I'm going to ask you a question nonetheless. How do you want to do your rebuttal?
I'd like to make about 2 statements, and then I'll turn it over to Mr. Meyer if he has any additional.
Sounds fine. I will start the clock upon your presentation.
All right. The problem, as pointed out in the Enriquez case and in our briefs, is that if you take out the limitation of applying the donor provision of this statute, if you take that out of the context of only applying in assisted reproductive technology situations, meaning laboratory handling of eggs or embryos, then you get back to the position that therefore any sperm donor automatically qualifies as a donor. There's no limiting factor if we take it outside that context. Any sperm donor is therefore automatically divested of any parental rights or obligations. You just transform paternity. Anybody who donates sperm no longer has to pay child support. They are relinquished of all obligations.
Is the court charged with writing a better statute or applying that which the legislature has given us, despite what we may think its faults are?
Our position is the court must read it in paramatrimon. I'm sorry, my Latin is not great, but you have to interpret it in a way that gives a function to all purposes. There is an interpretation as set forth in Enrique.
Is it a function of all purposes, or to make sure each word that's the legislature used is given its proper function? Because we're dealing with
Um,
language. You know, purpose sounds like you're like letting us maybe sit in the role of a legislature, decide what we think the purpose ought to be rather than what they actually said. If they got it wrong, I mean, there are
um,
unintended consequences. That's what we're here to point out.
It's our point that the legislature did provide the guidance. It put this provision within the assisted reproductive technology subsection. It clearly has entire areas of the statute that deal with pregnancy outside of matrimony. So there's no indication, you know, and of course you can't say, well, the legislature intended this or intended that, but clearly it would be a major revolution. I believe in one of the other cases, Budnick, it might have been, somebody tried this. Hey, I had sex with her, but I was just a donor because my intent was, you know, I wasn't supposed to be the father. It was just doing her a favor. And they ruled against that. That result would not follow if we followed AAB and had no internal limitation of the statute, the assisted reproductive statute that specifically includes this donor fundamental termination of fundamental rights. I refer the court to the answer brief that talks about DMT and the implications for interpreting a statute in a way that interrupts or affects fundamental rights in the most narrow way possible. So kind of the court does have to do some of that, but there is a clear reading per Enriquez that harmonizes all of this. Unfortunately, that means AAB has to fall and Enrique and DMT have to basically be harmonized as the law.
So if we are
No.
going to harmonize it, you're saying we're going to need to go on bond.
Yeah, you're going to have to. That's
Okay.
our position.
All right. Mr. Newhart, there's about a minute and a half left if you want to transfer that over.
Thank you. One point. So Judge Casanueva during the appellee's argument had sort of asked whether sort of a reformulated or paraphrased version of 742.14.
Yeah, I tried to paraphrase it, dealing because we have a male in this case. So I took out the language of the statute that might deal more specifically with when you're absolutely correct.
Right. No, right. But my point was, if you took that statute and said somebody who provides sperm for an artificial insemination process where the sperm is injected directly into the cervix of a woman forfeits his rights unless he's a part of a commissioning couple or a father who's a party to a pre-planned adoption agreement. That it would make no sense to do that because a commissioning couple, by definition, has to involve the handling of eggs outside of the body. And again, 742.15 makes clear exactly what the purpose is of identifying a commissioning couple. It's a party to a gestational surrogacy agreement. And again, as I said before, likewise, the father in this situation could not possibly be a party to a pre-planned adoption agreement because a pre-planned adoption agreement always ends with the person who gave birth to the child giving the child up for adoption to the other party. So here we have my client wants to raise a child with the biological father, but chose not to have sexual intercourse with him. And that is the right that we are trying to protect.
So one of the words that we might have to explore as you go through your argument is the word donor as distinguished from the word provider.
Well, that's right. That's really the crux of it because the word donor is not defined in the word donor is used only in 742.14 and it's not defined. And that's really the whole argument in between the dissent and the majority in Enriquez is whether donor means anybody who provides biological material in any form or fashion, or does it mean somebody who contributes this material for purposes of conceiving a child using assisted reproductive technology?
Okay.
That's the question. Thank you, Your Honor.
Thank you all. I think one of the things the Supreme Court has told us that this legislature doesn't do it. We're supposed to find an appropriate dictionary, which raises other interesting things. Do we go to Webster? Do we go to a medical dictionary? I mean, the questions keep rolling down the pike. And thank you very much to both of you on behalf of the panel for all three of you, pardon me, I'm used to having two at an oral argument, all three of you for your presentation today. Speaking on behalf of the panel, we very much appreciate your preparedness and your insight to the statute. Thank you very much.
Thank you, Your Honors.
I guess my job now is to call the second case, which is Geico Indemnity and Shazam.